Not much to say to start out with. I'm certainly glad that we're done with the presentation of evidence. That's always good, so at least we know what we're facing. And, this is sort of the fun part of the trial when I get to argue as though I think people listen to me. That's why we went to law school, but I know in reality it has nothing to do with evidence, but at least I get to try and put it together. We'll do that next couple of days and let the jury make their decision. Questions?
So George Zimmerman's decision not for him to testify, tell us about that. He seemed hesitant, was he, and how did you get to that decision?
Well, it's strange because for a year and a half he's been in hiding, trying to deal with everything that he has to deal with because of this onslaught of prosecution. And now we're done, and a big part of him wanted to get in front of the jury and talk to them and say, this is my story, this is what I've done, this is why I did it, and really wanted to sort of give his side of the story. So it was a very difficult decision for George to make. We talked to him, and again, like I said to you guys before, with the evidence the way it is, I think that we have a very, very good chance with the jury right now, and with the evidence as presented. He's already given his story, a statement 5, 6, 7 times now, so the jury has that, and we just decided that there was enough evidence in there that we didn't need to present anymore.
Was he leaning towards wanting to testify, and if you had to suggest to him that would not be in his best interest?
Well, I think he wanted to tell a story. I think that he really wanted to be able to interact with this jury and say to them, this is what I did and this is why I did it, and as importantly, this is what was happening to me at the time that I decided to do what I had to do. So in that sense, yes, I think he wanted to tell a story. We give the doctors the scalpels for a reason. We look at, and trust those, and I think he trusted us in the way we looked at the case and where things were. And I think that's the way the decision went in his mind.
Why did you never bring the marijuana evidence in after you worked so hard to get the judge to allow you to bring that in?
The what evidence? I'm sorry. That's these things are a judgment call all along the way. I think that it was relevant evidence. I don't think that it would have been. I agree with the judge's final ruling that it should be available to us should we decide to present it. And that's what the judge ruled. At that point, we knew we had the option. Then you fit that into your game plan, or you fit it into what you're looking at. I think now that we're done with the evidence, I hope that everyone understands. I hope that they believe that we presented this case in a way that did what we could and what we had to do to defend George zealously, but still protected the memory of the loss of a 17-year-old son of 2 people in that courtroom each and every day. So we had to sort of focus what we had to present to the jury in context of trying to be respectful to the event that happened, late that night, in a rainy night back in February 2012. And I think that impacted on the decision a lot.
What would be your argument against the lesser charges being included tomorrow?
But it doesn't apply. Self-defense is self-defense to everything. Self-defense to murder, self-defense to manslaughter, self-defense to battery. What happened out there was not a crime. So in that context, there shouldn't have been a second-degree murder charge, and there shouldn't be any lessers. In addition, I don't believe that factually a manslaughter charge would be presented. What George did was an intentional act in that he knew he was pulling the trigger. The reason why he did it was self-defense, and that doesn't suggest a manslaughter charge would be appropriate.
Is that a preview of your closing?
No. It's going to be much longer.
No, I know that.
Mark, you said that you didn't want you weren't going to want to respect Trayvon by not bringing up the marijuana, but you were prepared to bring in the text from his phone and the photographs.
No. In like form, we wanted to make sure that that was our decision in order to make that decision. And I think that the judge should have left that up to our discretion, but I certainly respect her decision. I think that, again, that I'm not going to revisit a court's ruling. I respect her decision. We had our reasons for wanting to have that as an option for us, and I'm fine with moving forward the way we are.
Do you think the actual animation will be used in your closing statements tomorrow? Will you use that?
Sure, I believe so. Why not? It's a great piece of demonstrative evidence or tool to give the jury an idea of what was happening that night. We now have, I think the Vantage Point movie connection that Mr. Ruth said is perfect. What we have is a lot of different people hearing or seeing a lot of different things, and I want to present it in sort of one cohesive form to the jury. I think they probably get it, but, you know, we have our toys and like to use them sometimes.
Mark, what's your client's state of mind knowing that his fate will be decided in just a couple of days?
He's very worried. I mean, I think he's happy with the way the evidence got out and that he's finally had an opportunity to have his lawyers present his case for him. But, you know, we still have a case where the state of Florida is trying to put him behind bars for the rest of his life. That's a very scary position to be in, and he's worried.
Mark, adding to that, how does Florida's 10-20 life law come into play here with this as self-defense?
It doesn't. They need a conviction before that applies. So we're going to deal with that if we have to. But certainly it just adds to the stress and adds to the fright of somebody who acted in a way where he had to do something he had to do to defend himself and to protect his own life, and now the state's trying to take away his liberty. We'll deal with it.
What's the strongest part of your case? Do you think, like, if you could look at how you presented your whole case, what do you think you hope the jury goes back with in their mind? What do you think you would want people to think about your case?
That George had no alternative, and he did what only that he believed reasonably that he had to do to protect himself from great bodily injury that was already being visited upon him. And if we presented evidence that helps the jury understand that, then we've done our job.
Do you expect more rebuttal evidence from the state tomorrow?
No, we're done.
What happened with Crump?
will be in?
We're done. There is no further evidence. They've made the decision not to move forward. We've both rested, and my understanding is that there is no further rebuttal, nor is there any surrebuttal.
What happened with Crump? You tried so hard to get him deposed and...
Again, one of those judgment calls. I don't mean to keep going back to the same answer with different questions, but the reality is we wanted his testimony, we wanted him as a witness, we wanted his deposition. Now that we have all of that, we fit that in, and had the decision been made to present him, we would have, but we had to fit it into the overall context of how you present this particular defense case. There are 200 witnesses identified and 80, I think, or 75 called, so there's another 125 witnesses we decided not to call.
Mark, question.
Lesser charges could be used as a compromise verdict.
Am I concerned about that?
If the lesser charges are included, are you concerned the jury could use that as a compromise?
Absolutely. I do not want this jury looking at this and feeling that the law suggests that sympathy should be considered, and a compromise verdict is nothing but sympathy. This should not be a compromise verdict. Whatever their decision should be, it should be an affirmative, just decision based upon the facts. I don't want them doing a jury pardon, which would let my client off because they feel sorry for him, and I don't want them doing a compromise verdict because they feel sorry for anybody else. We've done a very, very strong job of making sure that this jury gets evidence that they should get, they don't get evidence that they shouldn't get, and that they're going to follow the law and apply the law, and I don't want compromise verdicts or jury pardons.
Well, given the fact that Zimmerman was on the fence about testifying, does that give some kind of indication that he may not have been as confident that the case was strong enough?
No, I think he was confident in his desire to talk to his jury, but I don't think there was a lack of confidence in the way the case was presented.
Mr. Mayor, can you clarify potentially what lessers will go to the jury?
Well, my understanding is that manslaughter is what we call a Category 1 lesser. Aggravated assault may be another one that they consider. I don't think it's factually appropriate at all, but we'll talk about that tomorrow with the judge, and I think those are probably the only ones that would be considered.
Are those both with and without? I mean, is there like a manslaughter with a gun?
Yes.
Aggravated assault with a gun?
That's correct. Those are all variables.
Have mandatory minimum?
Yes, they do.
Mark, just to clarify, on the THC levels by Trayvon Martin, that will not be in any way accessible to the jury?
That is correct.
Not even in the autopsy report?
Of course not. No, it's not part of the evidence.
What would have been the downside for the defense to bring in the marijuana evidence?
Well, again, it's hard to say to take that one string out of a complete defense strategy and say, okay, let's look at this string by itself as though you really want to know what the tapestry looks like. But if you really want me to take that string out, it didn't seem to be significant enough intoxication evidence that it was worthwhile making the focus on that, because I am concerned about the jury's sensitivities. So, you know, whatever we do is always taking into consideration how the jury is going to view what we present. That, of course, impacted things like having to call Tracy Martin and other people to the stand. You got to look at that and weigh the positives and the negatives with any presentation of evidence, and that was one of the decisions we made.
Was it your intention all along, strategy can change from day to day. Was it your intention all along to begin with George's mother and finish with his father?
No.
Did you plan to get on that dummy this morning, or was that an impromptu thing?
The doll?
Yeah.
No, that was impromptu. It's just, sometimes those things come over you.
That the state has perhaps withheld discovery or committed some misconduct and should be sanctioned. Looking back now at the trial that you've arrested, where, if any place, did their actions hamper you, in your opinion?
In a lot of ways, I could say easily, I'm still frustrated that some of the phone evidence we got so late that we weren't able to do some of the background work that may have otherwise made it more admissible. So that's a point of frustration, particularly. We scrapped through it, We took what we got and we kept fighting until we got what we thought we needed. There's more that I wish I would have had, but I think within that context, we still were able to put on a pretty decent case.
Mark, just remind me, in a case like this, when the judge goes to charge the jury, the typical amount of time that takes to read all that paperwork for them?
Actually, reading the instructions seems like forever when you're listening to it, but it probably is a solid 10 or 12 minutes. That's about it. And of course, in Florida, we're allowed to have a copy of the jury instructions go back with the jury. So I started in the days when you just heard it once and then went and tried to remember it. So at least now they'll have it with them.
Mr. Mark, we've been told by both former prosecutors and defense lawyers that if either side requests the lesser included, the judge basically has to include them. Is that your understanding? What makes you think that they may not get in? How could you possibly block them?
Category 1s are sort of mandatory upon request. However, the judge still needs to make a determination that there's a factual basis to support it. You could not, for example, ask for a fact or a charge that is not based in any consideration of the fact. Right now, they couldn't go in and ask that the jury be charged on possession of marijuana by George because there's no facts to support it. I think that they are in the state's position that they believe there may be facts to support their lessers. I don't think there are.
You talk about if you go back to the jury, the lessers, what's the sentencing range?
Well, the sentencing range is anywhere from life imprisonment to he'll walk out a free man.
What about on the manslaughter charges? We're not sure what kind of penalty George would face should this jury come back with a manslaughter conviction.
You could face up to 30 years upon one consideration of how they may charge.
And Mark, the jury won't know what the sentencing guidelines are when they consider the charges, will they?
No, that's one not problem for defense attorneys, but the concern is that under Florida law, we can't advise them as to the penalties. That's up to the judge. Having said that, somebody may look at a second-degree murder charge and say, okay, I know that's serious, but maybe they think manslaughter is not. I really do believe that this jury has been listening attentively. I think that they're going to listen well to the instructions, and they seem very intuitive. So they're going to look at the law, apply the facts to the law, and make their decision. I don't think we need to worry about considerations of sentencing, jury pardons, or anything like that.
I want to judge still can do it. She can still tell them, she can, after her discretion, tell them the sentencing for a manslaughter.
Oh, no, she will not. No. They will not be, nothing will be mentioned about sentencing to this jury.
Mr. Romero, what will it mean to your client to have his parents in the courtroom finally for the closing? That would be
Very emotional, yeah.
What is George's kind of views, and does he think he will still be a pariah, and will his life actually be changed by an abortion?
I think that he's very worried about his safety, personal safety going forward, because those same people who portended the fear and hatred leading up to this trial probably are not going to accept an acquittal, though they should, since the system's working, but, we can't. Glad to hear that.
Will he make a public statement if acquitted?
I haven't made that decision yet.
Can you talk about
Interrupting the judge, as she tried to directly ask George Zimmerman if he understood his rights about testifying?
I think that was just a question of semantics or words. It always needs to be couched in terms of the defendant's conversations with counsel. And I think it was really just a momentary semantics issue more than, it definitely wasn't substantive. You could tell from the fact that he came back in a few minutes later and acknowledged. Okay.
Could you talk about the neighbor who talked about her house being broken into by 2 black males? You didn't go so far as to say, you didn't really mention Trayvon Martin and connecting them particularly, but what was that testimony about, and how did that help your case?
Well, you may not have been aware of this because there was a stipulation, but the last year's worth of burglary and other information that happened in Retreat View Circle is now of evidence. It was by stipulation, so you didn't hear about it, but the jury has to consider the last year's worth of alarms going off, burglaries and whatnot, so they know the context of why George was calling. And she was one of the most recent victims of the, and quite honestly, one of the most horrific victims of a home invasion where she's got to hide in the corner of a bedroom with her 4-month-old in her hands. And I thought that that was necessary to present to this jury.
What happened to the hearing about the restraining orders and the assault on police?
The hearing on what?
About letting that in.
Oh, no, that the state was considering something like that for rebuttal and decided not to. So that never needed to be ruled on by the court.
There were mentions of threat of rape to Don West's daughters. We were wondering if you were afraid for your safety or the family was as well.
You know, we've been very cautious throughout this whole thing, and there are ebbs and flows of people's animosities that show up. Certainly last week, when that was perceived to be some at least racially insensitive event, there was an upswell of that, but I think that's receded. Obviously, it wasn't a racially motivated event. Actually, a picture was taken 2 days before Ms. Gentile even testified, and I think that was all cleared up. But we're going to be cautious into the future. I think that there will be some people who are angry with an acquittal, and we'll work through it. And hopefully, they'll be at least willing to talk.
Were you surprised that the prosecution ended up with so few rebuttal witnesses and asked for so few to begin with?
Well, you know, their rebuttal is directly connected to what we present. What we presented was a lot of voice witnesses, and I don't think they had many voice witnesses to act in rebuttal. And we presented a couple of experts who talked about use of force and the Dr. DeMaio's testimony concerning how the event occurred. And they certainly had an opportunity to present their own experts, and they just decided that, I guess, in their minds, that they had presented enough, or at least that they had nothing else to present. All right, I've got to go to work. So, thanks very much.
I think the judge gave us